Calvin Okafor was 43 years old, and he had never once checked his credit score. He drove a dark green Explorer with a gym bag behind the driver's seat and a parking permit for the county courthouse hanging from the rearview mirror. He wore a good watch, not flashy. A brushed stainless automatic he'd bought himself the year he made partner. And he kept his dress shoes resoled rather than replaced, because he believed a well-built shoe, properly maintained, was better than a new one. He was a senior partner at Okafor & Trent, a 12-attorney civil litigation firm he had built from a 2-person practice over 16 years. He had argued before the state appellate court 4 times. He had won 3 of them. He had never once checked his credit score because he had never needed to. He paid his accounts in full every month. He had no debt. He had a discipline about money that was quiet and absolute, and not something he talked about, because a man who talks about his financial discipline usually doesn't have it. On a Monday morning, in April, he received a call from a fraud detection specialist at the bank where he held his primary accounts. The specialist said there were irregularities. She asked him to confirm several recent transactions. He confirmed none of them. She asked him to hold. She came back on the line 4 minutes later. Her voice had changed. She said she was going to need him to come into the branch. He came into the branch. What they showed him required him to sit down. What came next required a great deal more than that. Before we jump into the story, comment where in the world you are watching from and subscribe, because tomorrow's story is one you need to hear. The branch manager's name was Terrence. He was a careful man who had delivered bad news before and had developed the specific skill of delivering it without editorializing. He set a printout on the table between them and said, "Mr. Okafor, I want you to look at this and tell me what you recognize." Calvin looked at it. It was a consolidated credit report, all active trade lines, all accounts associated with his Social Security number. He had expected to see 2 accounts, his primary checking and the business credit line he kept for firm expenses. He counted 12 additional accounts, 12 credit cards, ranging in limit from $8,000 to $35,000, all opened in his name over a period of 23 months. He recognized none of them. The issuers were a mix of major banks and retail cards he had never used. 11 of the 12 were at or above 90% utilization. 3 were over the limit. The total outstanding balance across all 12 was $341,200. He looked at the printout for a long moment. He looked at the opening dates, which were organized chronologically. The first account had been opened 23 months ago. The most recent had been opened 11 weeks ago. He thought about 23 months ago. He had been deep in a major civil case that had kept him at the office until 8 or 9 most evenings. He had been present at home, but not attentive in the way he would have been during a quieter season. He had trusted the household to run itself, because the household had always run itself. And the person he had trusted to manage it had given him no reason to look more carefully. He looked at the name on the report. His name, his Social Security number, his date of birth. He put the printout face down on the table. He asked Terrence for a glass of water. While Terrence was getting it, he sat alone in the small office and thought about what he actually knew, what he needed to know, and in what sequence he was going to find out. He was a litigator. He knew how to build a case. He had never imagined he would be building one in this direction. He asked Terrence 2 questions before he left the branch. The first, had anyone else been into the branch recently to inquire about his accounts? The answer was no. The second, could the bank preserve all transaction records associated with all 12 accounts, original application records, and any supporting documents submitted during the application processes, and flag any further activity until he called back? Terrence said he would handle it personally. Calvin walked out of the bank branch into the April morning and sat in the Explorer for a moment. He started the engine. He drove to the office. He cleared his afternoon. He called his accountant. He called his firm's managing partner, who was also his closest friend of 22 years. And then he called a woman named Adice Morrow. Calvin had spent 16 years building Okafor & Trent from himself and one associate, working out of a rented office above a dry cleaner, into a 12-attorney civil litigation firm with a reputation that brought clients from 4 states. He had done it the way you do anything that takes 16 years, steadily, with attention, without cutting corners on the fundamentals, because in litigation, as in construction and engineering and medicine and every other discipline where the stakes are real, the corners you cut in the foundation show up in the structure eventually. He was the kind of attorney who read every document in full, who kept his own timeline of every case, independent of the official docket, because he had learned early that the official record reflects what people filed, not always what actually happened. Who cross-referenced discovery documents not looking for what they showed, but for what was conspicuously absent. He had met Diane at a bar association event 9 years ago. She was sharp and quick and had a talent for entering a room and immediately understanding its social architecture. Who deferred to whom, which relationships were performing, and which were real. He had admired that skill because it was one he had developed professionally and had never seen deployed so naturally and unconsciously in a social setting. They had married 3 years later. He had not asked for a prenuptial agreement because he had trusted the person. And because at 34, he had not yet fully understood that trusting a person and protecting a situation are not the same discipline. He understood it now. Diane managed their household finances. This had been her suggestion. Early in the marriage, she had pointed out that he worked 80-hour weeks during major cases, and that someone needed to be tracking the domestic accounts, the utilities, the insurance renewals, the property taxes. He had agreed because it was reasonable, because she was organized and capable, and because the domestic financial picture had always been simple enough that the risk of delegation seemed negligible. He understood now that the risk had not been negligible. He understood now that the simplicity had been a managed appearance rather than a fact. He thought about the previous 23 months. He had been managing 2 major cases simultaneously, one of which had gone to appellate argument. He had been at the office until 8 or 9 most evenings. He had come home to a household that appeared to run smoothly. Bills were paid. The house was maintained. Diane had her own career. She ran a small luxury event planning company, well regarded in the local market. Profitable enough to be real, but not so consuming that it demanded the kind of hours his practice did. She had the time. She had the access. She had, apparently, the plan. He thought about the things he had noticed and filed. A conversation 14 months ago about a wire transfer she said was for a vendor deposit for a client event. He had seen the amount on a screen as she was entering it, $14,000, and had thought it was high for a deposit, but had not asked because he trusted her judgment about her own business. A credit card statement that had arrived by physical mail 7 months ago from an issuer he didn't recognize, that she had taken from the pile of mail before he could look at it and said it was a client's card she'd been waiting for, forwarded to their address by mistake. He had not thought about it again. A dinner party 4 months ago, at which Diane's closest friend had mentioned, in passing, that Diane had been talking about a trip to Portugal. He had said he didn't know about any Portugal trip. The friend had looked at Diane with an expression that had lasted less than a second. He had filed it away. He had been wrong to leave that file unopened for 4 months. That was what she hadn't understood. Not that he was unobservant, but that his patience had a limit, and that limit was determined by evidence rather than by time. Her name was Adaeze Morrow. She was 60, with reading glasses on a tortoiseshell chain and the specific composure of someone who has processed other people's worst financial news for so long that almost nothing surprises her anymore. She had worked forensic accounting in criminal and civil fraud cases for 27 years. She had testified as an expert witness 43 times. She had never been successfully cross-examined in a way that altered her findings. Calvin had used her as an expert witness in 3 cases. She had never failed him. She arrived at his office that afternoon at Fort Ducko with a rolling case of equipment and a yellow legal pad. She poured her own coffee from the pot in the conference room and sat down and said, "Tell me everything chronologically. Don't interpret. Just tell me what happened in the order it happened." He told her. She wrote for 31 minutes without asking a question. When he finished, she set her pen down and looked at her notes for a moment. "I need 3 things," she said. "Access to the bank's preserved records on all 12 accounts, applications, identification documents submitted, transaction histories, IP addresses if available on the online applications, access to your household financial accounts for the past 24 months, and access to whatever records your firm's bookkeeper has on any expense reimbursements processed in Diane's name or paid to her event company in the past 2 years." Calvin said, "The firm has never had a financial relationship with her company." Adaeze looked at him over her glasses. "I know what you believe," she said. "Tell me what the records show." He was quiet for a moment. Then he said, "I'll have everything to you by Wednesday." She said, "Good." She refilled her coffee. She said, "Without looking up, you came to me before you went home tonight. That's the right sequence." "I know how to build a case," Calvin said. "You're not building a case," she said. "You're preserving one. There's a difference. Building a case is adding things. Preserving one is making sure nothing disappears before you know what it is." He looked at her. "What do you think I'm going to find?" he said. She said, "I think you're going to find that $341,200 is a floor, not a ceiling." She was right. He didn't move fast. He moved with the specific, controlled patience of a man who has watched opposing counsel move too quickly and has spent a career benefiting from that error. He understood, more precisely than almost anyone in that county, what evidence preserved was worth versus evidence that had been reacted to, challenged, contaminated, or lost. He did not go home and confront Diane. He went home at his usual time, ate dinner at the usual hour, and said nothing that was not ordinary. He answered her questions about his day with the usual compression. Long day. A hearing. Fine. He noted the way she asked about his afternoon, which she did not usually do. He noted the slight elevation in the specificity of her questions. He filed it and said nothing. Adaeze called him the following Monday. She had worked through the weekend. The 12 credit card accounts had been opened using a combination of Calvin's identifying information, his social security number, his date of birth, his firm's address as the mailing address on early applications, and falsified supporting documents. 3 of the applications had included a copy of his Bar Association membership card, which was publicly listed but had been reproduced in a format that had been submitted as identification. 2 had included a falsified employer letter on Okafor and Trent letterhead confirming income. The letterhead was accurate. The signature on the letter was not his. Adaeze had found the IP addresses for 8 of the 12 online applications. All 8 had originated from the same internet service provider account. The account registered to their home address. The transaction histories told the rest. The $341,200 had been spent over 23 months across 4 categories. Travel, $87,400. Retail and luxury goods, $114,000. Cash advances and transfers, $96,800. Miscellaneous services, $43,000. The cash advances and transfers had moved through 3 intermediate accounts before arriving at a destination Adese had traced to an LLC. Belmont Curated Events, LLC, registered in Diane's name 18 months ago. Different from her operating event planning business. A second company, quietly established, quietly funded. The ceiling Adese had predicted, $341,200 on the credit cards, plus $78,000 in household account transfers over 23 months that had gone to Belmont Curated Events through a series of transactions too small to individually trigger any notification threshold. Total, $419,200. Calvin looked at the forensic summary Adese had printed and bound, 47 pages, every transaction sourced, every transfer traced, every application document identified. He looked at the falsified employer letter. He looked at his own letterhead with someone else's version of his signature on it. He stood over it the way he stood over the evidence package in a major case, not looking at any single document, but looking at all of it together. Feeling the architecture of it, understanding not just what had been done, but how it had been designed to avoid detection, and for how long. 23 months, 12 accounts, $419,000. He looked at everything on the table. He could see the whole shape of it. He picked up the phone. He called the county district attorney's office. He asked for the financial crimes unit. He said his name. He said he had a case to report and that he had 47 pages of documented forensic evidence ready to present. The detective assigned to the case arrived at his office the following morning at 9:00. Her name was Sergeant Philippa Brand. She was 46, with a precise, unhurried manner and the habit of asking one question at a time and waiting fully for the answer before asking the next. She read the forensic summary in its entirety while sitting in Calvin's conference room. It took her 1 hour and 11 minutes. When she finished, she looked up. She said, "Mr. Okafor, I want to ask you something. You are, I understand, an attorney." He said, "Yes." She said, "And you have spent the past 8 days building this file. You have not confronted your wife. You have not frozen any accounts. You have not made any action that would have alerted her." He said that was correct. She said, "Why not?" He said, "Because I know what happens when a target is alerted before the evidence is secured. They move assets. They destroy records. They construct alternative narratives while the documentation is still in flux." He paused. "I was not going to let that happen." Sergeant Brand looked at him for a moment. Then she said, "All right. Here's what we're going to do." The arrest was made on a Thursday morning, 12 days after Calvin's first visit to the bank branch. Diane was at home when Sergeant Brand and 2 officers arrived at 8:14. Calvin was at the office. He had been there since 7 Nulo. The charges filed were identity theft in the first degree, 12 counts, 1 per account. Fraudulent use of a financial instrument covering the falsified employer letters and the reproduced identification documents. Wire fraud covering the electronic transfers to Belmont Curated Events. The total charge exposure under the state's enhanced penalties for identity theft involving a domestic partner was significant. The case did not go unnoticed. A senior partner at a major litigation firm, 12 accounts, $419,000, falsified documents on his own letterhead. The courthouse reporters had it by Thursday afternoon. By Friday morning, it was in the Regional Business Journal. By Friday evening, it had been picked up by 2 national legal trade publications and a financial fraud news aggregator with a following of 400,000 subscribers. The headline that circulated most widely read, Attorney discovers 419K identity theft scheme, quietly builds criminal case before calling police. Calvin did not read the coverage. He was aware of it the way a man is aware of weather on a day when he is focused on the work. Diane's attorney entered a not guilty plea and moved to suppress the IP address evidence on jurisdictional grounds. The motion was denied. The bank's application records, the forensic summary, and the IP evidence were all admitted in the preliminary hearing. Belmont Curated Events was frozen pending proceedings. Its accounts held $61,000. The credit card issuers, on notice of the criminal filing, suspended the balances pending fraud determination. Calvin worked with a DASE and a consumer credit attorney to formally dispute each account as fraudulently opened. The process took 4 months. At the end of it, not $1 of the $341,200 appeared on his credit report. His credit score, when he checked it for the first time in his life, sitting at his desk on a Tuesday afternoon in August, on a whim, because the case was resolved and he was curious, was 811. He looked at it for a moment. He closed the tab. The dissolution proceedings ran parallel to the criminal case. Calvin's family law attorney was methodical and patient. The marital estate was small relative to the fraud, the house, 2 vehicles, standard accounts. Diane had no claim to the firm. The dissolution was final 6 months after the arrest. The terms were straightforward. Calvin did not seek anything beyond what was equitable. He did not punish her through the civil proceedings. He had already done what needed to be done through the correct channel, which was the criminal one, and he did not believe in doing the same thing twice. He answered every call the same day. He went back to work. 14 months after the Monday morning at the bank branch, Okafor and Trent took on its largest case in the firm's history. A $28 million commercial fraud matter that had been referred by a client who had read the national coverage and, as he told Calvin over the phone, had decided that anyone who could build a criminal fraud case on themselves while continuing to operate normally was probably the person he wanted managing a $28 million fraud case for him. Calvin told his managing partner about that call. His managing partner laughed for a long time. He hired a 13th attorney in the spring. He promoted his most senior associate to junior partner in September and gave her the news on a Wednesday afternoon in his office, 2 cups of coffee on the desk, the city visible through the window behind him. She said, "I wasn't sure this day was coming." He said, "It was always coming. We just had an interruption." He answered every call the same day. He kept the Rissoled dress shoes. On a clear evening in early November, Calvin Okafor sat on the back steps of the house he had kept in the settlement. A glass of water on the step beside him, his jacket still on from the office. The neighborhood was settling into the hour after dark, traffic fading, lights coming on in windows, the air carrying the specific coolness of autumn coming in for the night. He thought about the Monday morning in April. He thought about the branch manager's printout, 12 accounts, none of which he recognized, his own name at the top. He thought about sitting alone in that small office for 4 minutes while Terrence got him a glass of water, and what he had done with those 4 minutes, which was to begin, as precisely and quietly as a man can, to understand what had actually happened and what he was going to do about it. He had done the right things in the right order. He had not moved before the evidence was secured. He had not reacted when reacting would have contaminated the record. He had built the case the way he built every case, methodically, completely, without assuming the conclusion before the analysis was finished. He was a litigator. He knew that what you preserve determines what you can prove, and what you can prove determines what justice can actually do. He picked up the glass of water. He finished it. He went inside and turned out the light. I hope you enjoyed that one. Be sure to like the video and subscribe so you don't miss the next story. I've picked out 2 more for you that I think you'll really like.